Peace to the gods. Peace to the gods. Yusef here. Got a good show lined up for you today. Someone posted a very interesting case in my Facebook group, and it had to do with the passport. I'm just turning off all this stuff because I don't want to get interrupted while I'm doing this. And it had to do with the passport and whether or not one needs a passport or a social security number to get, whether you need a birth certificate or a social security number to get a passport. And this was a very interesting case on a number of fronts because I got a glimpse of seeing how the Supreme Court will defend the right to privacy. This was a foot in the door where, we need to push through it. It's definitely a foot. Now, this did have to do with religious rights. If anyone has always listened to me, you always hear me say that, people talk about the common law, but, they don't like to talk about God, so it's a lot of protections as it relates to God or your religion, your religious belief, your sincere religious beliefs, as it says in this case that we're about to read. So, peace to everyone. Peace, peace, peace. I wanted to just kind of go over this case and let's just see what the case is talking about, because I know it's going to start spreading through a lot of different circles. People are going to be talking about it, and I already seen it start, so I thought I'd get ahead of the curve and just start talking about it and read the entire opinion of the judge with you so we can decide what this is really saying. All right? All right, so let me pull up the...
All right, so today we are looking at the basic building blocks of critical thinking. And this is not just for critical thinking.
Yusef here. Sorry about that. Got a good show lined up for you today. I don't need that either. All right, so we go back to the, here we go. We're going to read this case. Put this somewhere over here. All right, cool. Oh, yeah, I almost forgot. Just a second, y'all. Okay, there we go. Cool. All right, cool. All right, so everything is straight. The audio is straight. Y'all can see everything on the screen fine. All right, let's get to it. Like also, if you're just joining, this is a case that was sent to me about the passport, whether or not you need a birth certificate and a social security card to get a passport. And to me, it really, I did a cursory examination of it, of course, before I went into this, but I just wanted to go into a more detailed examination of it. But it seems to be legit. It seems to be very legit, but there is a lot. All this is predicated on someone's religious rights. Religious rights. let's get to it. Well, this is in the United States District Court for the District of Columbia. It's not a Supreme Court case. Abigail Carmichael Jordan is the plaintiff, and Marco Rubio in his official capacity as Secretary of State. So I blow it up a little bit. Okay, Abigail Jordan has been trying to get a passport since 2019. The problem? A passport application requires either a birth certificate or a letter confirming that an applicant lacks one. And it is Jordan's sincerely held conviction that obtaining either form of documentation would endanger her religious scruples. The predicament has left Jordan dismayed. She feels called to evangelize worldwide, but does not want to sully her own beliefs to do so. Seeking resolution, she sued the Department of State and the Secretary of State, collectively the department, asking the court to declare she is a U.S. citizen and order the issuance of a passport. Jordan originally filed pro se, and the circumstances on the ground remained stagnant. But once the court approved Jordan's request for counsel, the department's whistling took on a different tune. State and federal officials suddenly cooperated to attain the proper documentation for Jordan in a manner that did not violate her religious beliefs. And the department represented that it stood ready to issue Jordan a passport so long as she filled out yet another passport application and submitted yet another photograph. Now the department insists the case is moot. Not so. Jordan continues to suffer consequences from the department's years-long refusal to issue her a passport. So much is obvious. She still lacks a passport. The court thus delves into the merits of Jordan's claims and finds that she is entitled to summary judgment on them. As for Jordan's religious freedom claim, the department imposed a substantial burden on her religious exercise when it demanded she obtain documents through a process that violated her religious beliefs. But the department has not presented a compelling justification to require Jordan to go through such a process, nor has it demonstrated that the process was the least restrictive means of achieving its national security interests. So on that score, the court will grant summary judgment to Jordan. Jordan merits summary judgment on her claim under 8 United States Code subsection 1503, which is a real interesting code section for nationals, violating the rights of nationals. She has made an unrebutted prima facie case that she is a national of the United States entitled to a passport. Notice right here where it says unrebutted. When you send your documents and they don't rebut them, the court ruled on that. She sent in her documents of what she claimed to be, and they didn't rebut it. This adequate remedy moots her claims under the Administrative Procedures Act and the Mandamus Act. All her life, Abigail Carmichael Jordan has avoided the perceived stain of a social security number. Her devout Christian faith teaches her that her God-given identity is sacred and that the allegiance she owes to her government as a citizen of the United States must be subordinate to her allegiance to her Creator. She thus rejects the possibility of being enumerated or marked by the government, such as by obtaining a social security number, as to do so would be treating the government as if it were God. Her parents share this belief. Indeed, her parents did everything in their power to ensure that she did not receive a birth certificate when she was born, including withholding her first name from hospital officials for fear that applying for a birth certificate will result in the issuance of a social security number. At the same time, Jordan's faith called her to make disciples of all nations, quoting Matthew 28:19-20. To carry out this mission, Jordan has been seeking a passport for 6 years. First, in 2019, Jordan applied for a passport and attached a sworn letter explaining that she lacked a social security number for religious reasons and that she did not have a birth certificate for fear she could be assigned a social security number if she applied for one. To bolster her U.S. citizenship bona fides in the absence of a birth certificate, Jordan attached several records, including a sworn declaration from her father, a certificate of her childhood baptism, and a childhood immunization record, among others. The baptismal record should be enough. This was not enough for the department. Most relevantly, the department stressed that Jordan failed to supply a statement from the appropriate state registrar of records certifying that there is no birth record on file for her. That is, the department needed a so-called letter of no record from Jordan to issue the passport without a birth certificate. A letter of no record is a documentary evidence that is necessary to confirm a first-time applicant's claim of non-existence of a U.S. birth record, which is essential in examining the purported citizenship claim of a first-time applicant. According to the department, the requirement that a passport applicant without a birth certificate obtain a letter of no record is critical in preventing not only identity theft and fraud, but is essential in upholding the integrity of a U.S. passport. One of the most common types of passport fraud includes using fake birth certificates or stolen identities when applying for passports. The letter of no record is a safety precaution to ensure that someone is who they say he or she is. Aiming to comply, Jordan visited Virginia's Office of Vital Records to request a letter of no record. But the office informed Jordan that she could not obtain one unless she filled out a form entitled Birth Certificate Information, which asked for her name at birth, date of birth, place of birth, hospital of birth, race, sex, and parents' names. Jordan was fearful that the submission of such information could be construed as a request for a birth certificate or could otherwise cause the office to create a stand-in record for her containing the same information, which could then be passed along to the Social Security Administration for issuance of a SSN number. And that's really interesting how any type of voluntarily giving of them any information, this person was very, very wise in understanding how to interact with the government and understanding what privacy is. And remember what I told you, public and private does not mix. So Jordan refused to fill out the form and did not receive a letter of no record. Her passport application was accordingly denied by the department. She appealed that denial, but never received a response. How many of us know about that? You appeal something and they just remain silent. 3 years later, Jordan again sought a passport. She explained to the department why she could not obtain a letter of no record consistent with her religious beliefs, and she submitted more evidence of her U.S. citizenship. But again, her application was denied because she had not submitted the letter. Jordan then brought this suit. She originally proceeded pro se. Upon Jordan's motion, the court appointed counsel and set a briefing schedule. Okay, see minute orders 12/18/2024 and 1/21/2025. Jordan's amended complaint brings 9 counts against the department and several Virginia officials, the Virginia defendants. Broadly, it argues the department and Virginia defendants infringed her right to religious freedom and violated the Administrative Procedures Act. And it seeks various forms of relief, including a permanent injunction ordering the department to issue a passport to Ms. Jordan or to provide her with an appropriate religious accommodation, a declaration that Mrs. Jordan is a U.S. citizen as entitled to a passport, and a writ of mandamus. While this suit was pending, okay, then this is real interesting because, okay, maybe you have to come up with if y'all got to, you better come up with a special passport with people claiming religious freedom. It's interesting how I tell you, got to accommodate them because this is their right. This is their right. While this suit was pending, Jordan contacted Virginia's Office of Vital Records to request a letter of no record again. The deputy director informed Jordan that the office would not issue a letter of no record because the office located a birth certificate on file with the name Baby Girl Carmichael. This tracked with an Ancestry.com search that revealed a similar certificate, which the parties learned about during the litigation. While it is unclear how this partial birth certificate was created, Jordan has her suspicions. When she was born, healthcare providers ignored her parents' pleas to avoid collecting DNA or any information from Jordan that could then be transmitted to the Social Security Administration under the Enumeration at Birth program, the way newborns obtain an SSN. Healthcare providers dishonored that request when they removed Mrs. Jordan from her hospital room in the middle of the night and drew blood to record her DNA. These same providers also initially stated that Mrs. Jordan could not be taken home until her parents provided her name for birth records, but ultimately relented. Still, this sequence of events likely resulted in the creation of a partial birth record for Jordan, which she never knew existed until now. Man, let me tell you something. This right here was so chock full of stuff that people have gone through. Them not wanting to get a birth certificate and them holding them hostage at the hospital, threatening to arrest them. Some people even got arrested for not allowing the hospital to issue them a birth certificate. All these different things, which should be your right. I shouldn't have to be forced to have a birth certificate or any of these things. And seems to be getting exposed right here with this right here, and this right here is very, very interesting. Let's keep reading. Meanwhile, the Department and Virginia defendants cooperated behind the scenes. In February 2025, they broke major news to Jordan and the court. The Virginia Office of Vital Records decided to forward the letter of no record to the department, of obviating the need for Jordan to fill out any offending form. All right, so she won that. Jordan then voluntarily dismissed her claims against the Virginia defendants with prejudice, not voluntary dismissal. As the deadline for Jordan's summary judgment motion loomed, the department informed Jordan that their letter of no record satisfied the documentary requirements for a passport. Okay? So it told Jordan that it would issue her a passport if she submitted a new application and current photograph. Department's reply to preliminary statement material facts 101. It also agreed to expedite her passport application and assign her a person of contact to facilitate the process. But Jordan remains unsatisfied. She has refused these offers, arguing that there is no sound reason why she should have to fill out another application to receive her passport. She also fears that this situation could repeat itself upon her inevitable passport renewal in a decade. More, she knows that the department could revoke her passport at any time and require her to submit a new letter. She sought a judicially enforceable consent decree from the department offering to terminate the litigation if the department signed on, but the department rebuffed that request. So Jordan proceeded to move for summary judgment against the department, filing the present motion. The department responds with its own motion to dismiss or, in the alternative, cross motion for summary judgment, contending that the case is moot and that, if not moot, Jordan's assertions found her on the merits. The court held a motions hearing and is now set to rule on the cross motions. So let's see. In a suit, if a suit is not a case or controversy under Article 3, the court lacks jurisdiction to hear it. That's interesting. North Carolina versus Rice, Volume 404, U.S. Reporter, page 244 and 246, year 1971. So when a party moves to dismiss for lack of case or controversy, such as by claiming the dispute is moot, the court evaluates that claim under Federal Rule of Civil Procedure 12b-1. Zuckerman versus, so they're letting you know in that way that these are not Article 3 courts. There's not case is under Article 3. It lacks jurisdiction to hear it. So the court evaluates these claims, and while the court will accept factual allegations and the complaint is true, those allegations will bear closer scrutiny in resolving a 12b-1 motion than in resolving a 12b-6 motion for failure to state a claim. Okay, Nepal versus U.S. Department of State. Okay, so, and the court may consider materials outside the pleadings in deciding whether to grant a motion to dismiss for lack of jurisdiction. While usually it is up to the plaintiff to show that the court has jurisdiction, all right, it is on the defendant to establish that a once live case has turned moot. Oh, okay, so once the case is, once they obtain jurisdiction and the case commences, if you want to say it's moot now, they got to prove that. Well, that follows the basic principle of law. He who asserts, the burden of proof is on he who asserts, not he who denies. That's what that principle that's being applied right there is. This is a formidable burden, Friends of the Earth, Incorporated versus Laidlaw, okay? A party is entitled to summary judgment if it shows that there is no genuine dispute as to the material fact and the movement is entitled to judgment as a matter of law. At the summary judgment stage, the court must examine the facts in the record and all reasonable inferences derived therefrom in a light most favorable to the non-moving party, Robinson versus Peasant. This mode of analysis serves to separate the jury functions of making credibility determinations, weighing the evidence, and drawing legitimate inferences from the facts from the district court's role as the arbiter of legal questions. When parties file cross motions for summary judgment, each motion is viewed separately in the light most favorable to the non-moving party, with the court determining for each side whether the Rule 56 standard has been met. The court begins, as it must, with jurisdiction, and it concludes that the department has failed to satisfy its burden of showing mootness. The court thus proceeds to Jordan's substantive claims and concludes that Jordan is entitled to summary judgment on them. A case turns moot and thus falls outside the auspices of Article 3 when the issue presented are no longer live or the parties lack a legally cognizable interest in the outcome. Okay, well, that didn't happen with her. In other words, the mootness inquiry asks whether events subsequent to the filing of the complaint have so transpired that the decision will neither presently affect the parties' rights nor have a more than speculative chance of affecting them in the future. All right? A defendant bears the heavy burden of showing that a live controversy has expired. Right? Which was the state. Still, there's a wrinkle in this general rule. If the controversy's expiration stems from the defendant's voluntary cessation of allegedly illegal conduct, the tribunal is not deprived of power to hear and determine the case. In other words, the defendant cannot moot out a case by shaping up once it gets sued. Otherwise, the defendant could go back to its old shenanigans once the court got out of the way. This is known as the voluntary cessation exception to mootness. Now that's interesting. That just taught me something right there. Never heard of that before. When a defendant argues a case is moot because it has willingly stopped the challenged conduct, the defendant must make two more showings to prevail. First, it must show that there is no reasonable expectation that the alleged violation will reoccur. And second, it must show that interim relief or events have completely and irrevocably eradicated the effects of the alleged violation. Man, they clamping down on them. It's a good thing this girl, she must have some good counsel to tell her what to do, because she clamped down on them. They offered her a deal, which was a pretty nice deal, but she didn't take it based off the premise that it might happen again in the future. You know, just because it might happen again in the future, which is great because that she defended the rights of everybody. By doing that, she defended the rights of everybody. The department has not satisfied this arduous burden. The department has not satisfied. Hold on, let me see. The department has not satisfied this arduous burden. To begin with, the court affirms that this case is best understood under the voluntary cessation framework. The department argued to the contrary at the motions hearing, contending that it is not the department which voluntarily cease unlawful conduct, but rather the State Office of Vital Records. That's interesting. They put it on Vital Records. Yeah, that because they are the ones that relented and released the letter. That was the holdup. The letter was the holdup. That was the issue between the plaintiff and Virginia. That wasn't a situation that could be controlled by the Department of State. But yet still that requirement for that letter is the thing, though, still that needs to be addressed, this requirement for this letter. The department, the argument goes, has required a letter of no record all along. Now, with the letter in hand, it is prepared to issue Jordan a passport. According to the department, it is the state office that suspended the requirement that Jordan provide personally identifiable information in order to obtain a letter of no record, by ultimately giving the letter to the department of its own volition. Thus, any doctrine that contemplates the department ceasing challenged conduct, the argument proceeds and is inapt here. I mean, I think that's a pretty good argument. I think they're making a pretty good argument. Let's see how this goes. This is pretty interesting. The court sees things differently. Before this lawsuit was filed and counsel was appointed, the department was adamant that Jordan herself supplied the letter. See, and then it has the exhibits, I guess. Once counsel started clamoring, the department shifted course, initiating efforts to independently obtain the letter from Virginia's Office of Vital Records. Department's moved, blah, blah, blah. After the filing of the amended complaint, and in an effort to resolve this matter, undersigned counsel certifies to the court that he worked with the Virginia defendants to obtain the letter of no record. Jordan's contemporaneous efforts failed. Her counsel wrote to Virginia's officials explaining Jordan's religious objections and requesting that the office conduct a search of its records and, upon confirming that no birth record exists for Mrs. Jordan, provide her with a statement of no record of birth. Bastia exhibit, and then giving the exhibits right there. Jordan's counsel stressed that he would pursue appropriate legal action if the letter were not provided within a reasonable time. The office responded weeks later by telephone informing Jordan's counsel that it was declining to issue the letter because the office had located a birth certificate with the name Baby Girl Carmichael. Okay, another exhibit. And it stated that it could not provide Mrs. Jordan with documentation of any kind unless she applied to amend the existing partial birth certificate to add her first name to the certificate. Try to backdoor and trick her into try to get her to accept that partial birth certificate they already had. Boy, man, public officials, I'm glad y'all reading this to see, because they really do get down like this in a lot of different ways. And they're being exposed right here. I don't quite remember a time of reading a case of them getting exposed to this degree. So it says, though Jordan's own attempt stalled, the department's prevailed. The office forwarded the letter directly to the department, which then shared it with Jordan and her counsel. Thus, the department suspended a practice which Jordan objected to, the requirement that she obtain and supply a letter of no record. This makes the voluntary cessation doctrine a clean fit, and the department has not met its burden to overcome the voluntary cessation exception to mootness. It starts off well. The department has satisfactorily shown that it is absolutely clear the allegedly wrongful behavior could not reasonably be expected to reoccur. Friends of the Earth, Volume 528, U.S. Reporter at page 190. The department's counsel has represented that the department will keep the letter of no record in Jordan's file so her passport will not be revoked or ineligible for renewal based on the absence of the letter or birth certificate. The court credits this assertion. It is settled practice fully to accept representations such as these when determining whether official conduct will reoccur. All right. Relying on government counsel's representations in court when assessing voluntary cessation exception. More, only a first-time passport applicant must supply either a birth certificate or letter of no record. So even if the department were to eliminate the letter from Jordan's file and go back on its word, Jordan would still be eligible for a passport renewal. Put differently, there is no basis to conclude that Jordan will ever have to obtain a letter of no record or a birth certificate again. Jordan's argument to the contrary sounded conjecture. She insists that the department could revoke her passport at any time and demands she provide a new letter or birth certificate. I don't think it's a stretch, but such speculative contingencies do not show that challenged conduct is likely to reoccur. In the absence of evidence that this is a prospect of immediacy and reality. Stressing that plaintiff's speculative fears were a wholly inadequate basis to find a reasonable chance of reoccurrence. In other words, the department has met its burden to show that there is no reasonable expectation that the alleged violation will reoccur. Jordan may not rebut this showing with mere speculation. Okay, she lost that point. According to Lawson versus U.S. Navy, plaintiffs cannot overcome government's mootness showing where the record contained no evidence that plaintiffs' fears of reoccurrence would materialize. The department has met its burden on the first element of the voluntary cessation test, but it falters on the second. Jordan continues to face consequences from the denials of her passport applications. While the department represents that it stands ready to issue Jordan a passport, it refuses to do so unless Jordan submits an updated application with a new photograph. These extra hurdles constitute effects of the alleged violation. Had the department dispensed with the letter of no record requirement and acknowledged Jordan's copious evidence of citizenship off the bat, she would have the passport now. I like that, Jordan's copious evidence of citizenship. Copious means a lot, you know. I love reading this. Judges are very, very eloquent with the English language. I just love it. And she would not be forced to exert more time, energy, and money to obtain a passport that all agree is rightfully hers. The department may think that these are nothing more than diminished administrative burdens. Diminished is probably Latin for small. Guy minimus means small. Arguing that this case is not a sound use of counsel or the court's time. The idea that the department should, oh, they didn't insulted the court, talking about it's not a use of time. We shouldn't even be arguing this. They didn't put that in their pleadings. Damn, they said that to the judge. No wonder they're getting reprimanded like this. The idea that the department should have to forego other policies does not preclude the case as being moot, but it does not point to any case law that establishes a threshold for when ongoing harms count and when they do not. Further, delays and obligations surely suffice. Indeed, in a related vein, the Supreme Court has acknowledged that a plaintiff's request for nominal damages can keep an otherwise moot case alive. True. I negated the Supreme Court case right there. This reflects that even seemingly small forms of relief are concrete and effectuate a partial remedy. Thus, the possibility of their issuance can provide redress to a plaintiff. Similarly, in the standing context, courts have roundly recognized that the amount of economic harm is relevant to the standing inquiry, as a dollar of economic harm is still an injury in fact for standing purposes. The department has not shown the court why it should depart from these precedents, collective wisdom that so-called minor harms, which still invite judicial relief, keep a suit in the land of cases and controversies. That was nice, how that was worded. He said his minor harm invites judicial relief. That was nice. I like that. Here, Jordan faces ongoing harms. The department is making her expend more labor before she can obtain a passport she should have received 6 years ago. Plaintiff's concrete drain on their time and resources constitute injury in fact. Those injuries can be avoided if the court intervenes. See infra, and they're giving a case law. Since an aspect of Jordan's injury persists that can be relieved by an appropriate court order, this case is not moot. And then giving a case law, man, they got to get case law on everything they got. They put up everything. The court therefore turns to the merits of Jordan's claims. They got supporting, controlling law for everything that they saying. Begin with Jordan's allegations under the Religious Freedom Restoration Act. Now, this is where it should get pretty interesting about the religious protections. I think this is took up a huge portion of the opinion by the judge. But this should be interesting. Let's see what it's saying. This statute provides that the government shall not substantially burden a person's exercise of religion unless it demonstrates that application of the burden to the person is in furtherance of a compelling governmental interest and is in the least restrictive means of furthering that compelling governmental interest. Now, this is something y'all always hear me talking about, compelling public interest or compelling governmental interest. You know, public and government are interchangeable terms. But right here, you also say it has to be the least restrictive means for the government to effectuate that interest as well. They have to put at least the least amount of restrictions on our rights as possible. And they got to be seeking to do that as trustees of our rights in the public. Very, very interesting right there. But, you know, you'll see this a lot in cases talking about compelling governmental interest test. You know, that's the public versus private. The government has to have a compelling public interest to encroach on private rights. It does not say in the Constitution that private property cannot be taken. It says it can only be taken with due process of law and just compensation. And to meet that due process requirement, they have to show a compelling public interest. Let's keep going. It says, whether the department has violated the Religious Freedom Restoration Act thus boils down to two phases. First, the court asks whether the challenged conduct substantially burdened the plaintiff's religious exercise. If so, strict scrutiny applies. For that stage, the court probes whether the imposition of the burden was in pursuit of a compelling government interest, and it queries whether the pursuit of that interest required imposing the challenged burden. This is a stringent and exceptionally demanding test. It is. Only if the answer to both strict scrutiny questions is yes can the department justify its behavior. Wow. That's a heavy burden on the department. We're going to look into this strict scrutiny test right now. This is going to be, this should be pretty interesting. Start with the substantial burden question. Jordan asserts that the department imposed a substantial burden on her religious exercise by saddling her with a dilemma. defy her religious convictions, or forego a passport. Jordan is correct. The department denied Jordan a passport application because she did not submit a birth certificate or a letter of no record. Jordan's religious convictions, however, prevent her from obtaining a birth certificate due to the unacceptable risk that a social security number will be generated for any individual with birth certificate information on file in Virginia, even when a social security number is not specifically requested. That's true. And they also bar from it. Is that revealing also that even if you don't ask for a social security number, they still give you one? Is that what that's showing? And they also bar her from acquiring a letter of no record, as its application leads Jordan to fear that it could be construed as an application for a birth certificate containing that information, or would cause the Office of Vital Records to generate some other stand-in record containing all the same information that could then be transmitted to the Social Security Administration for the issuance of a Social Security number. In short, the department withheld a coveted public benefit unless Jordan abandoned the teachings of her faith. Such carrot dangling is the classic example of a substantial burden on religious exercise. The rule is black and white. A person may not be forced to choose between following the precepts of a religion and forfeiting benefits on the one hand, and abandoning one on the precepts of her. I'm sorry, let me read that. Let me read that again. The rule is black and white. A person may not be forced to choose between following the precepts of her religion and forfeiting the benefits on the one hand, and abandoning one of the precepts of religion on the other hand. Thomas versus Reverend Board, whatever that is. Cleaned up, but here, that is precisely what Jordan was asked to do. Passport or salvation. Thus, she has been made to suffer a substantial burden on her religious exercise. The department's counter-arguments failed to persuade. First, the department argues that this case is controlled by the Supreme Court's opinion in Bowen versus Roy, volume 476, U.S. Reporter, page 693, year 1986, and derivatively, the D.C. Circuit's opinion in Camerling versus Lappin. It is not. Begin with Roy. A father objected to the state's use of his daughter's social security number when doling out welfare benefits. The Supreme Court held that this gripe could not support a free exercise challenge. Roy objected to the statutory requirements that state agencies shall utilize social security numbers, not because it places any restriction on what he may believe or what he may do, but because the use of the number may harm his daughter's spirit. But the court stressed that the free exercise clause simply cannot be understood to require the government to conduct its own internal affairs in ways that comport with the religious beliefs of particular citizens. Cheekly put, Roy could no more prevail on his religious objection to the government's use of the social security number for his daughter than he could on his sincere religious objection to the size or color of the government's filing cabinets. Okay, now that is very powerful. I hope y'all got that. That's a public and private thing. Okay, that social security number is the property of the government. You don't have no say-so over it whatsoever. That's what they just told you. I don't, which something that I always known, because you look on the back of the damn card, it says it's their property. So all that, you inquiring, they made this number, what they did with my number, set up account in my name. They could have did whatever they wanted to do. It's their property, not yours. I don't understand where y'all got these ideas that that's your account. It's not your account. You're getting to benefit from that account. You don't have any rights, title, and interest to it. This right here was a very, very, very powerful, right. You should take this and make a citation of authority out of it. Roy could no more prevail on his religious objection to the government's use of a social security number for his daughter than he could on a sincere religious objection to the size or color of the government's filing cabinets. It's their property. Because Roy did not object to a forced alteration of his own behavior, but offered a theological critique of the government's behavior, he could not state a free exercise claim. Beautiful. Ooh. Ooh. Do y'all understand that right there? Because Roy did not object to a forced alteration of his own behavior. In other words, nobody forced you to change your behavior, but offered a theological. That's what most of y'all fall into the trap of critiquing the government instead of identifying the injury. That said, 5 justices explained that Roy could not be compelled to provide a social security number on his family's welfare application. Free exercise of revisionism, blah, 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 blah. Okay? This did not become a holding of the court because one of the 5 justices believed the question was moot. Still, a majority of the court saw a clear distinction between a claim based on coerced personal conduct and a claim based on government's internal procedures. While Roy's claim fell on the latter side of this gulf, Jordan's is squarely on the former. Wow. These are some nice judges. She protests a mandate of her individual behavior, the requirement that she apply for a birth certificate or letter of no record, and spur the risk of being branded by the government. Unlike Roy, she's not objecting to the government's internal use of a social security number that has already been created. She has qualms about her own participation and complicity in the potential issuance of a social security number. The same conclusion goes with the department's reliance on Camerline. There, a convicted felon objected to the state's practice of collecting fluid or tissue samples from qualifying offenders to create a law enforcement DNA database. Camerline argued that the collection and retention of his DNA information is tantamount to laying the foundation for the rise of the Antichrist, which defied his strongly held religious beliefs about the proper use of the building blocks of life. Following Roy, the D.C. Circuit held that Camerline did not allege facts sufficient to state a substantial burden on his religious exercise because he cannot identify any exercise which is the subject of the burden to which he objects. Camerline did not object to the Bureau of Prisons collecting any bodily specimen that contains DNA material. Instead, he objected to the government. And now notice how the judges just told you what you were supposed to do. This is why you read case law. The judge right there telling you this is what you should have done. You should have objected to that, but you didn't do that. This is what you objected to instead. Instead, he objected to the government's extracting DNA information from the specimen. You weren't objecting to the collection of the specimen. You were objecting to the collection of the information from the specimen. You see how precise you have to be in law? That's why they say law is a science, man. You know, that's why I love it so much because, you know, when reading, I can appreciate the precision that is required. And I don't think a lot of, laymen can really understand the precision that's required in this space, man. It's a lot of precision. The circuit stressed that the extraction and storage of DNA information are entirely activities of the FBI in which Camerline plays no role and which occur after the BOP has taken his fluid or tissue sample, to which he does not object. Thus, like the father in Roy, Camerline's opposition to government collection and storage of his DNA profile does not contend that any act of the government pressured him to change his behavior and violate his religion, but only seeks to require the government itself to conduct its affairs in conformance with his religion. This type of theological critique did not constitute a substantial burden. That was cold. Dude he claimed the wrong thing, you know. He should have attacked the collection of the DNA in the first place. But he's sitting there saying, you know, I don't like what you're doing with what you collected from me. But can you see how the judge is not wrong? He's not wrong. These judges are not evil or anything. They're not wrong. They're absolutely correct in that assessment. That was beautiful. It says, again, Jordan's claims are not simply proselytization. Jordan insists that the department has put substantial pressure on her to modify her behavior and to violate her beliefs by forcing her to apply for a birth certificate or letter. Thomas, Volume 450, U.S. Reporter, at page 718. Thus, Roy and Camerline do not dictate dismissal here. Instead, the dichotomy they set up bolsters Jordan's allegations. Second, the department pokes holes in the reasonableness of Jordan's beliefs. It stresses that Jordan's parents could have obtained a birth certificate for her without risking the assignment of a social security number, as the SSA's enumeration at birth program is voluntary. I want everybody also to pay attention to how I've been saying in the past that it's not the birth certificate that is the problem, it's the social security number. That's why you keep hearing me say that. It ain't the birth certificate. She don't want a birth certificate because it can lead to getting a social security number. That's the only reason she don't want a birth certificate. She don't want that number because she believes that's the mark of the beast. And I can understand why. She don't want to put none of her information in their database. And she has that right. She has that right. And it points out that adults face virtually no risk of unwittingly receiving a social security number, as there is no enumeration program for adults whereby social security number is issued when they request a birth certificate. The department traces the path an adult would have to take to obtain a social security number, which includes filling out an application for a social security card, forwarding it with required documentation to the Social Security Administration for review, and potentially undergoing a personal interview. Thus, according to the department, Jordan's fears are unfounded. The court is disinclined to bicker about the way the system works. It very well may be that Jordan never faced a substantial risk of receiving an unwanted social security number at birth or during adulthood. But for Jordan's RFRA claim, the actual risk is irrelevant. What matters is whether Jordan sincerely believes that applying for a letter of no record conflicted with her faith, because it exposed her to the unacceptable possibility that she would be stained with a social security number. And there is no dispute that Jordan honestly believed this. So the court must credit her fears. It may not tell Jordan that she is mistaken about the dictates of her own faith. The care of souls cannot belong to the civil magistrate because her power consists only in outward force. But true and saving religion consists in the inward persuasion of the mind. And they got a memorial and remonstrance against religious assessments. Writings of James Madison. Okay. The religion then of every man must be left to conviction and conscience of every man. The opinions of men, depending on the evidence contemplated by their own mind, cannot follow the dictates of other men, nor may the court draw the line on the near occasion of sin. That's nice, man. Well, they substantiating their position. They just knocking down the state's argument at every turn. It's almost like they mad at them for something. They must have said something to piss them off. This conclusion is compelled by the Supreme Court's decision in Burrow versus Hobby Lobby Stores, Incorporated, Volume 573, U.S. Reporter, page 682, 2014. There, the proprietors of closely held corporations objected to a federal policy that required them to provide health insurance to their employees that covered methods of birth control that could destroy an embryo. These birth control methods conflicted with the proprietors' belief that life begins at conception. The Supreme Court held that the federal law imposed a substantial burden on these plaintiffs. If the proprietors did not yield to a demand that forced them to engage in a conduct that seriously violated their religious beliefs, they faced severe financial penalties. Such an intolerable choice, according to the court, was a substantial burden on religious exercise. Right here, this is all the evidence I need to see that our Supreme Court, they are defending our religious freedoms. If y'all can't see that from reading this right here, you know, a lot of people like to demonize the Supreme Court and say what they're not doing and so forth. But I don't really see that when I read a lot of Supreme Court cases. I see that the judges are following the law. And, you know, it's just a lot of people feel that they're right about something or that they've been wronged. They go off how they feel. The judges don't go off how they feel. They go off of what the law says. And y'all got to remember that. But this is nice right here. It says, in holding so, the court rebuffed arguments that the connection between what the objecting parties must do, provide coverage of potentially abortifacient contraceptives, is that what that is? Provide coverage of potentially abortifacient contraceptives, and the end that they find to be morally wrong, destruction of human life, was simply too attenuated to constitute a substantial burden. Such an argument, according to the court, dodged the question of the RFRA presents, which is whether a government policy imposed a substantial burden on the ability of individuals to act in accordance with their religious beliefs. Instead, the argument addressed a very different question that the federal courts have no business addressing: whether the religious belief asserted in an RFRA case is reasonable. The proprietors sincerely believe that providing the issuance coverage demanded by the federal regulations lay on the forbidden side of the line between prescribed and proscribed conduct. That was all that mattered. Now, look at this right here. This is nice. The proprietors sincerely believe that providing the issuance coverage demanded by the federal regulations lay on the forbidden side of the line, all right, between the prescribed and proscribed conduct. That was all that mattered. It was not for the court to say that the religious beliefs were mistaken or insubstantial, and that's absolutely correct. This, you know what? Let me just say this. Plus, they could have easily made the argument that we can go to Revelation chapter 13, all right, where it talks about the mark of the beast, all right? It is the mark of a man. He said, and they should not be able to buy or sell without the mark. And we know you can't eat, and we could have easily made the argument that, hey, I can't get anything in your system without getting this social security number. I can't get no benefits or privileges from you or participate in the system in any kind of way. So this goes right in line with what is being said right here in my Bible. So what do you mean, is this not reasonable? Even if they tried to push, the court struck that down. It ain't for them to decide if something's reasonable or not. But even if they could have made that argument, that would have been easy to defend. What you mean? This is in the tenets of my religion right here in the book of Revelations. It talks about all of this. It went easy to counter that. It goes on, it says, Hobby Lobby controls here. Just as the religious proprietors fear their participation in the issuance program could lead to their facilitation of abortive activity, Jordan fears that providing birth certificate information to the government may catalyze the issuance of a social security number, and asking to be so branded contravenes Jordan's faith. The honesty of this conviction cannot be doubted. Jordan herself was given a partial birth certificate without her knowledge or consent after hospital staff collected Jordan's DNA without her parents' approval. And one of her family members was issued a social security number against his will. This is understandable that Jordan sees the passport application process as a string of dominoes. And it is understandable that Jordan views filling out the paperwork as flickering the first domino in the line. That is all a court evaluating the RFRA claim can assess. That's nice. It's a domino. Everything begins with that damn birth certificate. Everything begins with that birth certificate. The department suggests that Jordan's case is different from Hobby Lobby. According to it, in Hobby Lobby, the proponents of the contraceptive mandate were attacking how the proprietors interpreted the tenets of their own faith. But here, the department does not doubt that Jordan's faith compels her to avoid the issuance of a social security number. Rather, the department only seeks to disprove the secular and factual belief that Jordan faced a risk of receiving a social security number. I don't think there's any realistic concern. But to deem a belief secular rather than religious is to beg the question. After all, we are judges, not moral philosophers or theologians. This is not a question of legal causation, but of religious faith. Nice. Faith implicates difficult and important questions of religion and moral philosophy that necessarily involves individualistic calculations of tolerable levels of risk and complicity. I love how that was worded. Somebody's faith implicates difficult and important questions of religion and moral philosophy that necessarily involve individualistic calculations of tolerable levels of risk and complicity. That judge a wordsmith. That's nice. I like that. I like that. Hobby Lobby, volume 573, U.S. Reporter, page 724. Sure, those calculations will use factual understandings as inputs, but an adherent's ultimate assessment of the risk, and thus her ultimate perceived degree of culpability, is the output, and that necessarily involves faith-based value judgments. I like how these judge you the reasoning, how they reach their conclusions through their reasoning skills. The mandate infringes plaintiffs' religious liberties by requiring them to lend what their religion teaches to be an impermissible degree of assistance to the commission of what their religion teaches to be a moral wrong. In other words, an adherent's understanding of the spiritual consequences of an action and her own concomitant blameworthiness is deeply personal and part of her faith itself. It is not the role of the court to correct that understanding by trying to prove her wrong. Even if Jordan is misguided in thinking that the scheme is spiritually risky, that is not the court's call to make under the first prong of the RFRA. Priest for Life versus the Department of Health. Okay, and I got all your case law there. Dissenting from the denial of rehearing in bank. That is, Jordan's legal interpretation of what triggers the issuance of an SSN is besides the point. What matters is whether her participation in the scheme, however minimal, violates her religious beliefs. And the record offers no dispute about that fact. Jordan sincerely believed that acquiring a birth certificate or applying for a letter of no record would violate her religious beliefs. That is where the inquiry stops, because Jordan was put to a choice between violating her religious beliefs and receiving a passport. She was made to suffer a substantial burden on her religious exercise. That brings the court to strict scrutiny. The department satisfies strict scrutiny only if it demonstrates that that the application of the burden to Jordan is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. Put differently, so long as the government can achieve its interest in a manner that does not burden religion, it must do so. This is a difficult hill to climb, and it was never meant to be anything less. The department does not surmount it. They said it was intentionally made hard for them to overcome that over religious freedom. That's a nice little thing to let everybody know how difficult it is to overcome your religious beliefs, which, you know, a lot of people, like I say, you're supposed to be, your religion should be your shield against what's going on. It's supposed to be your shield against what's going on. To begin with, the department has not shown that it has a compelling interest in requiring Jordan to supply a birth certificate or a letter of no record. It insists that the letter of no record is necessary to confirm the non-existence of a U.S. birth record and is essential in examining the purported citizenship of a first-time applicant, and is critical in preventing not only identity theft and fraud, but is essential in upholding the integrity of a U.S. passport. Okay? Perhaps, but as critical as these generalized interests may be, the departments cannot rely on them to satisfy its burden. The court must look beyond the department's broadly formulated interests and instead scrutinize whether the department has a compelling interest in requiring the particular claimant to satisfy the documentary requirements. The department does not even mention Jordan while making its compelling interest arguments, instead invoking abstract notions of national security untethered from this dispute. The department counters don't have no connection to this. The department counters by arguing that, man, who was their attorney, man? It's almost like this judge is like, boy, y'all incompetent. That's damn sure what it looks like. Okay, there we go. The department counters by arguing that it is not at liberty to determine that certain documents are not needed for some individuals like Jordan while requesting them from others to issue a passport. But that is precisely what RFRA requires of the department, requiring the government to show that the application of the burden to the person furthers the compelling interest. Stressing RFRA's focused inquiry on the asserted harm of granting specific exemptions to particular religious claimants. More, the federal law regulating passport issuance explicitly recognizes that passports cannot be conditioned on First Amendment activity. A passport may not be denied issuance, revoked, restricted, or otherwise limited because of any speech protected by the First Amendment to the Constitution of the United States. The department must accommodate when it is necessary. But the department has not even argued how eliminating the letter of no record requirement for Jordan and only Jordan would undermine its interest in passport integrity. They didn't. And this is also how they come back, and when they re-argue something, they fill in the holes because the court shows them all the mistakes they make, and they come in and make the corrections too. So the next time they argue it, they'll be ready. Perhaps this is because the department could not make such arguments if it tried. Jordan has provided abundant independent evidence of her citizenship. She has. It is unclear what a letter of no record from Jordan, a document that the department admits is not directly probative of citizenship, could add to the passport adjudication. No one suggests Jordan poses a risk to national security or is engaging in criminal conduct. Thus, the letter appears superfluous. It may be a wrought administrative requirement to the department, but it carries the threat of iniquity for Jordan. More, the history of these proceedings reveals that requiring Jordan to obtain a letter of no record was not the least restrictive means of carrying out the department's generalized interests. After some cajoling, the Virginia defendants forked the letter over to the department without involvement from Jordan. Indeed, Virginia law envisions these circumstances by allowing state officials to provide this information directly to the federal government. Clearly, then, the department did not lack other means of achieving its desired goals. While the department insists that it had no obligation to seek the letter on behalf of Jordan, replies to the plaintiff's statement of material facts, RFRA may in some circumstances require the government to expand additional funds in efforts to accommodate citizens' religious beliefs. The department could have worked with the Virginia defendants from the beginning, thereby eliminating the need for Jordan to pay a spiritual toll. When a potential compromise like that exists, the department cannot show it pursued the minimally onerous path. Wow. You got to go all out to accommodate these people. I hope y'all are getting all this about the religious beliefs, man. They shot all this down. With the RFRA claim resolved, the court proceeds to Jordan's claim under 8 U.S.C. subsection 1503A. This provision authorizes any person denied a right or privilege by any department or independent agency or official thereof upon the ground that she is not a national of the United States to institute an action in the federal district courts for a judgment declaring her a national of the United States. And then 8 U.S.C. 1503A, this category of rights and privileges includes a passport. To prevail under 1503A, Jordan need make only a prima facie case establishing her citizenship by birth or naturalization, at which point the burden shifts to the government to present clear, unequivocal, and convincing evidence rebutting the plaintiff's showing of citizenship. And she showed that with her baptismal records and all of that. And they didn't properly rebut any of it. Jordan is entitled to relief on her subsection 1503A claim. The department concedes that Jordan is a U.S. citizen and Jordan has proffered a body of evidence establishing as much. Thus, Jordan is entitled to the issuance of a passport, and the court will order the department to provide Jordan with the passport right away. A final note on remedy is in order. The court will provide Jordan with the injunctive relief she requests, an order directing the department to issue Mrs. Jordan a U.S. passport forthwith. The traditional scope of injunctive relief is the extent necessary to protect the interests of the parties. Georgia versus Presidents of the U.S., Volume 46, is a federal fourth edition of Federal Reporter, page 1,283 and 1,303, 11th Circuit, 2022. Any injunction should be limited to the inadequacy that produced the injury in fact that the plaintiff has established and no more burdensome to the defendant than necessary to provide complete relief to the parties. Gill versus Whiteford. Okay, Jordan's harm stems from the department's persistent refusal to issue her a passport in violation of her rights under RFRA and subsection 1503. Absent such violations, Jordan would now have her passport in hand without the need to shoulder additional administrative burdens and costs. Thus, an injunction directing the department to issue the passport is necessary to remediate Jordan's injuries. Such relief is not unduly burdensome to the department. The most recent photograph and home address that Jordan provided is only 2 years old. The typical lapse between passport application is 10 years, the duration between issuance and renewal. So the department is not made to suffer unwarranted harm by issuing a passport without mandating Jordan's jump through additional hoops that Jordan likely perceives and endlessly proliferating. It is time that the court releases Jordan from the bureaucratic funhouse. The Constitution does not contemplate that judges be spiritual arbiters. If someone sincerely believes she risks her salvation by taking some action, the government may not condition a benefit on her doing so. To find otherwise would be to arrogate an abhorrent authority. To find otherwise would be to arrogate an abhorrent authority. The court will not oblige Jordan to follow an agency's assessment of her personal convictions. She's entitled to summary judgment and a passport. Oh, man. That was a good case. That was a good case right there. That was a good case. That was a good case. I like that. I like that. I like that. I like that. Okay. What y'all think about that? What y'all think about that case? Let me go to the comments, see what y'all comment on. What y'all think about that case? Think about that case. That case was how can we use that case to, I feel like that is a doorway, even if you have a social security number and a birth certificate. All right. And if your religious belief is that, hey, I feel like this is the mark of the beast and I want to reject this particular number. Okay, now they have a SSA 521, but that's not really to get rid of the social security number. It's really to reject a claim that you've made with the Social Security Administration. It's just my sincere belief that, to reject all this stuff, that you have to write just formal letters to them and do an administrative process through a letter writing campaign. And then you have to change your conduct as well, too. But I just think that case that we just read definitely opened a door. It might have opened Pandora's box for individuals who are, seeking to remove themselves from the public or from any type of, nexus that they may have with the government. This looks like that may be a good opportunity too, especially in the passport process. But I would think before you get a passport without a social security number or anything like that, that you first of all start an administrative trail by first rejecting it, saying, I don't want the social security number and I want all these documents rejected. And you have a history, you have a documentary evidence administratively that shows that you've already taken this route, and then go up to the passport and then attempt to get your passport without your birth certificate or social security number. And then when they request that, well, if you've ever been issued one, we need to see it. Well, I have been formally rejecting, this number, and I've already done so numerous times months ago before this, and tell you that I'm rescinding the social security number and any nexus that I may have shared with this particular number for religious reasons. And it's very easy. I mean, the problem today is most people don't even study their religion, and they've turned their back on religion because of the liberals. The liberals, because most of their conduct is outside the tenets of mainstream religion, they demonize all the religions. And so a lot of people have, kind of bought on with that or jumped on that board and demonized the religions. But the religions contain a lot of protections in them. And because there are certain spiritual principles that they all contain. And you'd be a fool just to simply completely reject them without understanding what those principles are. But, that's what I see. The religion, we always talk about the common law, but a lot of people don't like to talk about God, but they want to talk about the common law. I just find it interesting. The common law is the unwritten law. Some guys always writing trying to tell me what the common law is. Look, man, common law is judge-made law. It can be no other way. It can be no other way. All right? Because common law is an unwritten law. If you have a law, that means that there's a law there, and potentially there could become two people that will have some sort of conflict, okay, that needs to be resolved, and the law is going to be the thing that resolves it, okay? Once they come together and they say, well, what is their problem? And they both give the facts of the case, and a third party, which is a judge, he decides what facts weigh more heavily in one person's side and give the reasons, and he applies the principles of the common law to that and writes down his opinion. That's the evidence of the common law when it's come into the material world, because the common law is unwritten law. It's a body of customs and principles and rules that people lived under. So you got to understand it. That's why you got to read court decisions. These guys, you don't understand what you're talking about when you talk common law. Another name for common law is judge-made law, stare decisis, case law, whatever you want to call it. And you got different areas of it. Like you have a federal common law, all right, which is the body of judicial decisions in their administrative courts, all right? Federal common law. All right, then you have state common law. So you got different areas of common law, of judge-made law. So don't get confused about that. Common law is the unwritten law, but we're not under common law. We're under this is a statutory law that is conducive to corporate activity. These laws, the government's responsibility is to regulate commerce. They regulate business activity. And in the world today, modernization of society means that everybody the more modern you are, the more connected you are to the corporatocracy. The more modern you become. You're using these cell phones, the cars, all this stuff are created in corporations. They have their commercial items that have serial numbers on them, and they have the authority to regulate it. You know, true freedom is when you do everything for yourself. You do everything for yourself. You build your house yourself. You got your land yourself. You protect your land. You know, everything yourself. That is true freedom. That is how the United States of America was, you know, at its inception. And that's what the Constitution is protecting, that freedom right there. And I think a lot of people, you know, just from me studying this for a long time, people have some misconceptions about some things, a lot of things, because when they come to the door, you know, I know it makes me sound arrogant, but I listen to a lot of individuals. I was listening to somebody talking about consultations and people getting rich off people and shit like that. Man, I've been doing this a long time. I've charged $49, and I work my ass off on my website. I'm at class teaching, making everyday researching, handing out free information. I try to give out information where you don't need to get a consultation from me. I'm going to tell you what the answer is and put it out there for everybody to see, you know. And still, you know, it's just that people, there's so much bad information that has been spread. And I really see that now, just how much. And so many people, and the bad information is the information. This is the bad information. The bad information is the information that everything you hear, it goes in your favor. You know, like you're listening, like the public don't have any rights or anything like that. It's just that I'm the sovereign and I have complete authority over the government. That is kind of like this prevailing attitude, which is the wrong attitude. It's really, you shouldn't even be using the word sovereign. It's really public and private rights is what we, you know, well, technically what we're talking about. You have this sovereign power that you're talking about only if you're in the private, if you're completely in the private. So as a private sovereign citizen, or I don't even like not sovereign citizen, but as a private American citizen of the republic, okay, that's what that judge is protecting with her, because there's a separation of church and state as well. That's public and private as well. Your religious conviction is a private matter. That is the covenant that you have between you and God. All right, so that's a private matter. So they can't infringe upon that. But they are our public servants, but they're offering benefits and privileges. But they can't be, we can't be denied a benefit or a privilege. Because we don't want to, you know, give social security numbers and things like that, especially if we're not working in their system. So, you know, so I like how the case went, but I think that, you know, a real understanding of public and private, you know, if you maintaining your private rights is what is this really going to help with that particular case. I think the judges did an excellent job in that case, in my opinion. If you have done the SBC, probably filed or removed it. I don't know what people just started watching. What about the issue of back child support? Please don't say pay your child support. It's not owed to my ex. It's owed to the state, and my son has passed. Okay, well, sue them. You know, you have to, y'all gonna have to start suing these people. Somebody asked me about back child support. Okay, well, use what you use with this. Sue them, discharge it, then sue their ass. Bring them their agency. They're a debt collector. That's what they are. Child support is a debt collection. Discharge that shit, then sue their ass. Take their ass to court and see what happens. I'm like, look, I'm gonna sue y'all motherfuckers to get rid of this. And see. You'll be surprised at what happened. That's what this lady just did. She just sued them. You know, I remember one time we were having trouble filing UCC1s down in Fulton County in Georgia. And the clerk, she wouldn't file them. And then she just told her, she said, you got to sue me. They making me do this. She said, you got to sue me. You know, when they give you a letter saying why they won't file a UCC1, that's an attorney opinion letter. That is not anything from a court or case or anything. You got to sue them. What they're saying to you is, I'm not going to file it, and I got the support of the attorney general in case you want to sue me for not filing it. That's what they're saying to you. And sometimes you got to test their ass and sue them. Okay, well, sue them. Sue them. They pass laws all the time that are unconstitutional. They trying to get what they, like that senator said in that video, the role of the U.S. Supreme Court under the Constitution, when Justice Brian Scalia was right there in front of the at that judicial committee. And that senator said, as much as we can get away with. They pass laws and try to get away with a lot of stuff. Even though, and Justice Scalia reminded them, you took an oath just like I did. You reminded to stay within the ambit of that delegated authority. But they will, but he sat there and let them know that they will go outside of it if they can get away with it. And there's also a ruling on the book that if you engage a public official and you don't ask them what their delegation of authority is, then there is a presumption that you acted in accordance with an understanding of what the extent of his authority was. In other words, you always ask them what their delegation of authority is, the extent of it. You always ask a public official that. All right, y'all. Where are we at? All right, well, that is it for me. I just wanted to hit y'all with that case. That is a very interesting case. It looks like you don't need a birth certificate. You know, if you strongly held religious beliefs and you want to apply for a passport, you've just seen firsthand, but they cannot require you to have a birth certificate or a social security number. And I've said for a long time, don't get your children social security numbers. I don't think there's a problem with the birth certificate, but with the ways that she just argued the case, I do now. You know, I like what she said. You know, it's like you don't want to give them any of your information. You don't want your name in their system at all. Hey, if your name is not in their system at all, you know, if people just stopped putting their name in their system at all, what would happen? And people just started making their own schools again. And, you know, just build your own schools, you know, for all the children. We don't need to be, you know, that's how they get to make, I believe that's how they make you go take your children to a public school. You know, like, no, don't put their name in the system at all. No birth certificate, no social security number, no nothing. I'll keep a record of it. I don't need you to do it. I'll go home and get their footprints, and I can put them on the little thing and memorialize it, have everybody get it witnessed by some family members and some friends, some family members and some friends. I can memorialize the birth of my child. I don't need the state to do that. I can memorialize the birth of my child. You know, just something to think about. Anyway, and what happened? Did a complete breakdown last week. Something in this case is going to change a lot of things in the system. Okay, somebody, I just did a complete breakdown of it. What is that a breakdown? It's a good case. It's a good case. I mean, the government had a weak argument. The argument was came. They couldn't fulfill that two-prong test. One of a kind. Thank you. I appreciate that. Peace. Peace. Yeah, it does open up for the Amish to get passports and some other people. Definitely the Amish. That's what I was thinking too. That the Amish definitely can, but anybody can because see the whole thing about status correction is based off the fact that you engaged in these contracts with the public, but you weren't given full disclosure of all the material facts related to the acceptance of the benefits and privileges that they're presenting to you. And now you want to rescind those contracts. That's what status correction is. It's rebutting any presumptions that you voluntarily submitted to their jurisdiction, with full knowledge of all the material facts associated with it, the acceptance of any benefit or privilege that they, pretend to give. But so that's the whole premise of status correction. So yes, I still think that people should do their status correction, and that right there may be definitely an avenue to go and acquire your passport without providing any of the documents that are, attached to a benefit and a privilege of the government. I read this. I think it was a law review. It might have been a Harvard law review. I don't know if it was a Georgetown law review or Yale law review, but it was about the passport and how it was unconstitutional. And the arguments were made that the government made that it was for national security that they have to require the passport. And that's why that national security overcame its unconstitutionality. The argument made. But it is unconstitutional because you should just be free to leave and go and forth. You should be able to egress anywhere on this world that you want to, But, I understand in modern times, national security. You got economies and all kind of things going on. But, like I said, you shouldn't be required to jump through all those hoops and prove that I'm a U.S. citizen. I just want to try this with Georgia DMV. They require a Social Security number to get a driver's license. That would probably be an interesting case. Georgia started doing the same thing. They started first, people weren't given that. And they said if they put in there in the statute that if you've ever been issued a Social Security number, then you have to provide one. So that is the hurdle you're going to have to contend with is the issuance of one. They want it, if you've been issued it, then you have to provide it. And it's in a statute. Now, how are you going to approach that argument? That's up to you. But that's what it says. My mother's family were Mennonite, but my father was Irish. Catholics, that's why I have a Social Security number assigned to me. Well, most of us have a Social Security number assigned to us. What was interesting, though, is when I got mine at 18. I got mine when I turned 18 years old. I didn't have one from birth. I remember when I went and got my Social Security number because I was going to get a job and start working. And that's how they used to do it back in the day. You didn't get a Social Security number right off the bat. You went and got a Social Security number when it was time for you to go get a job and go, and start working. It says after getting a state citizen passport, you can use it to update your DMV and get an unrestricted DL. All right, that might be something. That sounds like a pretty good suggestion. My mother's family were, okay, I read that. Yeah, egress, yes. Move about. After getting it, I don't see nothing else. All right, well, look, I'm going to get off now. I appreciate everybody tuning in. Like, comment, and subscribe. I'm interested in your opinion of this case. And I will be answering the comments down in the comment section. I got to get to work, and I got some other goodies coming for you. Also, make sure you subscribe to the channel and you push the notification button, all notifications. Like this, because it's good for the analytics, okay? Peace, and I'll hit you on the next one.